Good morning, everybody, and thank you for joining us for the Tax Practitioners webinar. This is our first webinar of 2026 entitled Protect Your Practice. My name is Trevor Hickman. I'm joining you from Ngunnawal and Ngambri country, and I'd like to start with a quick acknowledgement of country. I respectfully acknowledge the traditional owners and custodians of country throughout Australia and their continuing connection to land, waters and community. I'd like to pay my respect to them and their cultures and elders past, present and emerging. I've now got a few quick housekeeping messages. First, you can access the slides in the platform today, or you can obtain a copy by visiting our webinar resources hub at tpp.gov.au/webinar-hub. Don't forget, we'll also email you a copy of the slides straight after the webinar. Today's webinar counts towards your continuing professional education or CPE, and you can claim 1 hour for attending. In relation to claiming your CPE, we'll issue an attendance certificate for those staying on for the duration of the webinar, and that comes to you automatically. So we'll just click over to the next slide and what we'll cover today. So today we'll start with an overview of how to safeguard your business and clients. Next, we'll review steps to take when engaging with disqualified entities. After this, we'll discuss best practices for client verification and POI. To wrap up, we'll answer some of your questions, so please keep them coming throughout the presentation. We're lucky to have subject matter experts, Isabel, Kristen and David, on hand to answer your questions, and they'll endeavour to answer them as we go. Now, I'm delighted to introduce our speaker for today, TPB board member Amanda Gascoigne. Amanda's a highly experienced accounting professional and leader with over 30 years in the industry, having founded and run her own successful practice and now consulting to firm owners through Amanda Gascoigne Consulting and her community, The Balance Firm. She owns significant governance and advisory roles, including co-chair of the ATO's GST Stewardship Group. Without any further ado, welcome Amanda, over to you.
Thanks so much, Trevor, and welcome everyone. Thank you for joining us for today's webinar. Today we're going to be discussing, a very important topic about how you can ensure that your practice has adequate processes in place to protect both your business and your clients. So when we talk about protecting your practice, this can cover a broad range of matters across all aspects of the Code of Professional Conduct in the Tax Agent Services Act 2009, which I will refer to in the webinar as simply the Code and TASA. So next slide, please. Yeah, so for the purpose of this webinar, our focus, as Trevor said, is to be focusing on disqualifying entities and proof of identity checks in relation to protecting your practices. We do recognise that the vast majority of tax practitioners are honest, compliant and do already have strong and robust systems in their practice to safeguard their practice and their clients. However, a small minority of practitioners either engage in illegal conduct or simply lack these adequate safeguards, which can leave them really, really vulnerable to exploitation by tax criminals. So in addition to our increasing reliance on technology to conduct our businesses and our remote working practices, it just means that the risk of becoming a target of fraudulent activities is high, and it's getting higher. So it does require you to be, extremely vigilant and to continuously review your practices to ensure that they are robust and secure. So we urge you to take appropriate checks before you employ or engage people to provide tax agent and BAS services on your behalf, and also when you onboard new clients into your practice. So they will be the main things that we'll be focusing when it comes to disqualifying entities and proof of identity in today's webinar. And we're going to cover the minimum requirements to help you understand and undertake those checks. Next slide. So the steps that we recommend to take when engaging with disqualifying entities are as follows. So, and these are obligations under the code. And so before we actually discuss that, let's look at the obligations under the code to see what we refer to when we talk about disqualified entities. So TASA defines a disqualified entity as an entity that is not registered, not a registered tax practitioner or a qualified tax relevant provider, and that has had one or more of certain events occur in the last 5 years. So an entity that is currently registered as a tax agent, a BAS agent, or a qualified tax relevant provider is not going to be considered a disqualified entity. So when we say entity also, what we refer to is both or all of individuals, companies, partnerships, and trusts. Because I know a lot of people think just the entities when we think about more structures, it does actually include individuals. So next we need to know what those specific events are that are going to make an entity disqualified. So here we go. So an entity will be considered a disqualified entity if within the last 5 years any of the following events have occurred. So the entity has been convicted of a serious taxation offence, convicted of a serious offence which is an offence against an Australian law that is punishable by imprisonment for a period exceeding 12 months, convicted of an offence involving fraud or dishonesty, penalised for being a promoter of a tax exploitation scheme, or penalised for implementing a scheme that has been promoted on the basis of conformity with a product ruling, which in a way that is materially different from what is described in that product ruling. The entity has become an undischarged bankrupt, even if that individual is no longer an undischarged bankrupt, or gone into external administration, even if that entity is no longer under external administration, has been found to have contravened the TASA through our investigations or by court, had sanctions imposed for failing to comply with the code, had their registration or renewal application rejected for eligibility reasons other than for failing to meet education or experience requirements. The entity has had their registration terminated due to an event affecting continued registration having occurred, ceasing to meet a tax practitioner registration requirement, or breaching a condition of registration. So there's a lot in there. So now that we've discussed who those disqualified entities are and what events can lead to an entity becoming disqualified, we'll now need to see what your obligations are in relation to engaging one to provide a disqualified entity to provide tax agent or BAS services on your behalf. So there are 2 code obligations that relate to using disqualified entities in the TASA, and they are code item number 15 and code item number 16. So code item number 15 says that you must not employ or use the services of an entity that you know or ought reasonably to know is a disqualified entity to provide tax agent services, which does include BAS agent services, on your behalf unless you have obtained the TPB approval. Code 16 prohibits you from having certain arrangements with an entity that you know or ought reasonably to have known is a disqualified entity in connection with the provision of tax agent services. So when we refer to the term know, it refers to actual knowledge. So actual knowledge that you know something. And the phrase ought reasonably to know extends to where the existence of that matter could be discovered by a reasonable person in the same position as the person making reasonable inquiries. So there's 2 distinctions there. Next slide, please. Yeah. So when we talk about you must take reasonable steps and make reasonable inquiries to determine if an entity you employ or use to provide taxation services on your behalf is a disqualified entity. And these reasonable steps and inquiries to include new information gathering processes for entities providing tax agent service, such as when you're onboarding requirements for new employees or other entities in your practice, and employee reporting processes or contractual notification requirements for non-employee entities. So the steps that, next slide, the steps that we require at a minimum that you take the following steps to an inquiry is to comply with your code obligations. So step number one is to check if the entity is or was previously registered. And that is, you should check if the entity is registered as a tax or BAS agent with the TPB using the TPB public register search on the TPB website. Then check if the entity is currently registered as a qualified tax relevant provider or a QTRP with ASIC or using their financial advisors register. So as I mentioned before, if that entity is currently registered as a tax or BAS agent or as a qualified tax relevant provider, it is not going to be considered a disqualified entity. So it's only if it comes up that it is actually, that they're not registered. So step number two to identifying the disqualified entity is to undertake the following steps before you employ or enter into an arrangement with an entity to provide tax agent or BAS services. So what to conduct there is appropriate proof of identity checks on that entity. So this process will be similar to the POI checks that you're required to undertake on your clients, which we'll discuss later in the presentation. But we need to look at the requirements of code item 15 and 16 with the entity. So you need to discuss the requirements of those with that entity. And also obtain a written confirmation from the entity that they have not had a disqualifying event occur within the last 5 years. And you can use that disqualifying events declaration and consent form to obtain this written consent. And you must retain this form for at least 5 years after you ceased your relationship with that entity. You also need to we recommend having a written contract or arrangement with the entity that requires them to notify you as soon as possible if a disqualifying event does occur, and that enables you to immediately cease employing or using them if they do become disqualified. However, you should be alert to your obligations under employment and contract law, and we recommend that you do seek independent legal advice regarding your obligations where necessary. So where you already have an existing contract or arrangement in place with an entity, we do recommend following those steps that I've just discussed to ensure that you have processes in place already to comply with those code obligations. So, just go and check what you have if you are actually already employing anyone, whether it's an entity. So if a disqualified entity must actually notify you in writing of their disqualified status before they are used or employed to provide tax agent services on your behalf, or enter into an arrangement with you in connection with tax agent services that you do provide. If an entity becomes a disqualified entity while they're being used or employed to provide tax services on your behalf or in an arrangement, they must notify you within writing within 30 days of when they do become aware or ought to have become aware that they are a disqualified entity. And disqualified entities can provide this notification by completing the disqualifying events declaration and consent form, and they must provide a copy to you. If they do fail to give notice, the disqualified entity may be subject to civil penalties, and the maximum penalty that can be applied is 250 penalty units for an individual and 1,250 penalty units for a body corporate, with the current value of a penalty unit being $330. So if you have ascertained that someone that you do want to employ or use is a disqualified entity, to the TPB for approval to comply with code item 15. And as I mentioned earlier, you must also first obtain written consent from the disqualified entity to apply to us for approval. Written consent by the disqualified entity, completing the disqualifying events declaration and consent form, and providing this to you for your application. So to lodge an application, log on to my profile to access our approved form, and you will need to provide relevant information to support your application, which includes the reason why the entity is a disqualified entity, the circumstances of the entity that led it to become disqualified, the role that that entity would perform or is performing in your practice, and the reasons why the entity's ability to perform their role or proposed role to an appropriate standard of professional and ethical conduct would or would not be affected. And then any other relevant matters that you would like us to consider. We must make a decision on your application within 60 days of receiving the application, unless we have agreed with you on a longer period. Once we have made a decision, we will notify you in writing. If we reject your application, we will provide you with the reasons for that decision. If we do not make a decision within 60 days or the agreed longer period, your application is taken to be rejected. And if your application is rejected, you can apply to the Administrative Review Tribunal for a review of our decision. So next slide. Oh, that's already done. Thank you. Then we'll move on to Code Item 16, which prohibits you from having certain arrangements with a disqualified entity in connection with the provision of tax agent services. And the term arrangement is defined broadly and can include any arrangement, agreement, understanding, promise or undertaking, whether express or implied, and whether or not legally enforceable between the registered tax practitioner and the entity. Code Item 16 is intended to prevent arrangements where a disqualified entity is operating through the registered practitioner. And this may occur where the disqualified entity is acting as the controlling mind of the registered tax practitioner and provides tax agent services while unregistered, using the registered tax practitioner's credentials. And the circumstances which may constitute an arrangement for the purpose of Code Item 16 can vary significantly and will be considered on a case-by-case basis. Unlike Code Item 15, arrangements under Code Item 16 are prohibited and cannot be approved by us. So now let's look at a few case scenarios to put this into context. See if there's any questions there. Okay. So we have scenario one. In this scenario, we have Sebastian, who is a registered tax practitioner who wishes to enter into a contract with Head Proprietary Limited, or Head, for the provision of tax agent services on his behalf. So Sebastian will use Head to provide tax agent services relating to transfer pricing for some of his clients, which he will then use to finalise and lodge his clients' tax returns. Head provide a range of professional services and are expanding these services to include services relating to transfer pricing. However, Head is not a registered tax practitioner company. Head also has two employees, Mark and Nancy, who are not registered tax practitioners either. Nancy is a disqualified entity and is the only employee who will actually be involved with the transfer pricing services. So to meet his obligations under Code Item 7, Sebastian is required to provide adequate supervision and control over the services being provided by Head and its staff on his behalf. So, for example, he must review the documents prepared by Nancy on behalf of Head before he uses these to prepare his clients' returns. Sebastian is also required to ensure that he has TPB approval to use any disqualified entities in providing tax agent services on his behalf. So in this scenario, Sebastian has two entities, Head, who is the contracted entity, and Nancy, who is an employee of Head, being used to provide the services. So prior to commencing the contract with Head, Sebastian requests that Head complete a disqualifying events declaration and consent form. In the form, the entity notes that Nancy is employed and will provide the tax agent services on Sebastian's behalf. Nancy also completes a separate disqualified events declaration and consent form and declares that she is a disqualified entity. Sebastian makes an application to TPB for approval to use Nancy as the employee of Head and to provide tax agent services relating to transfer pricing on his behalf. In the application, Sebastian further details on the limited services Nancy will be providing and the level of supervision and control that he will actually perform. So the TPB approves the application for Sebastian to use Nancy as employee of Head to provide tax agent services on his behalf, and Sebastian and Head do commence their contractual arrangement, and Nancy commences providing transfer pricing services for Sebastian's use in preparing his client's tax return. So there is, a process to go through, and in this case, that has been approved. So moving on to scenario 2, in this example, Cheryl is a disqualified entity and is seeking to enter into an arrangement with James, who is a registered tax practitioner, in connection with the tax agent services provided by James. James undertook a proof of identity inquiry in respect to Cheryl and discusses disqualifying events that could prevent her from entering into the arrangement. James received a written declaration from Cheryl that none of these events applied to her. James also conducted a search of the TPB public register for Cheryl, and her details did not appear on this register. James ensured that the arrangement with Cheryl included terms requiring Cheryl to immediately disclose whether she is or becomes a disqualified entity. During the period of employment, James discovers that Cheryl is a disqualified entity, and upon discovering that she's a disqualified entity, James immediately ceases his arrangement with Cheryl in providing tax agent services. So James has undertaken reasonable inquiries and has complied with his obligations under Code item 16 of TASA. So why compliance matters? So let's talk about, move on and talk about the benefits of strong compliance. But firstly, I would like to explain why the Disqualified Entities Amendment was actually introduced and has applied from 1 January 2024. The explanatory memorandum of the Treasury Laws Amendment 2023 Measures Number 1 Bill amended the TASA to raise ethical and professional standards for TAS and BAS services. The bill introduced obligations and civil penalties that disqualified entities must disclose their status, and tax practitioners must not employ, use or enter into arrangements with disqualified entities without TPB approval. So compliance isn't just a regulatory requirement, it also assists in safeguarding your business. The TPB focuses on governance, system and agent behaviour, not just technical tax accuracy, so it's important to have this correct in your organisation. The Code of Professional Conduct sets out the minimum professional standards for all registered agents. Honesty, integrity, independence and confidentiality are not optional but enforceable obligations. And this extends to ensuring that documented procedures are maintained. Through strong compliance, your exposure to sanctions, investigations and reputational damage is reduced, and this in turn builds trust amongst your clients. The message is that good governance supports consistent service delivery and reduces operational risk. So compliance should be seen as a strategic asset in your practice, not a burden, and it really does strengthen your practice and will protect your clients. So let's finish by let's look at the next part of our webinar, which is discussing the TPB's proof of identity requirements, so that you can take appropriate steps to verify your client's identity, which in turn will help protect your business, the Australian community, and our tax and superannuation systems from identity fraud. So what I'll be discussing today are the TPB's POI requirements. As you will know that from 1 July 2026, Australia's anti-money laundering and counter-terrorism financing, so the AML-CTF regime regulated by AUSTRAC, will be expanded to cover high-risk services provided by certain industries, including the accounting sector. So this may impact registered tax practitioners if they provide those designated services from that date. So yesterday, the TPB board had an excellent presentation from AUSTRAC, and last week, AUSTRAC released their accounting program starter kit. So what the TPB are doing at the moment is reviewing our own POI guidance in light of these upcoming changes to the AML-CTF regime to ensure that impacted tax practitioners meet their obligations under both TASA and AML/CTF regulatory regimes, including in the context of client verification. So the TPB is developing new guidance to assist registered tax practitioners to understand any obligation overlaps and similarities between the two regimes. So that we will have further guidance coming for that. In the meantime, registered tax practitioners should refer to the various publications, see if they're going to be impacted and what their obligations will be. So why is client verification important? As we discussed at the beginning, we're all working in an environment where remote working and increasing reliance on technology is now the norm. This, however, brings many positives to our profession, but it also does increase the risks of fraudsters, attempting to steal people's identity, which could be used in criminal activities, including tax fraud. So as a tax practitioner, you have responsibility to protect the Australian community and our tax and superannuation systems from identity fraud. Our POI guidance explains our minimum requirements in relation to verifying a client's identity. And the guidance should help you enhance your client verification processes so that you can minimise the risks of falling victim to identity crime. So while there are no specific POI requirements in the TASA, there are several provisions that you may breach if you fail to take appropriate POI steps to verify a new or an ongoing client's identity. Any representative of new or ongoing clients and the representative's authority to represent the client if applicable. So the items of the code that we're referring to here are code item number 1, acting with honesty and with integrity. Code item 7, ensuring tax agent services are provided competently. And code item 9, taking reasonable care to ascertain a client's state of affairs. The fit and proper requirement, and section 50(20) of the TASA, which is a civil penalty provision, which registered tax and BAS agents can breach if they knowingly or recklessly make statements or lodge documents with the ATO that are false, incorrect, or misleading in material respect. So you must undertake POI checks prior to providing tax or BAS agent services when onboarding new clients. For existing clients, you should also undertake POI on an ongoing basis as appropriate, and we'll discuss this a little bit later. But let's look at what information and evidence you will need to verify when a new client or their representative comes and seeks to engage you. So for individual clients, you will need to verify the client's full name and either their residential address or date of birth. For individual clients using a representative, you will need to verify both the clients and their representatives' full names and either their residential addresses or dates of birth. The authority of the representative to engage you on behalf of the client and their authority. So for individual clients and representatives, one primary photographic ID document will be sufficient. So this will include documents such as a driver's licence, Australian or foreign passport, or a government proof of age card issued in Australia. If there is no photo ID, both a primary non-photographic ID and a secondary ID will need to be cited. So a primary non-photographic ID will include documents such as an Australian or foreign birth certificate, a citizen certificate, or a government-issued concession card such as a pensioner concession card or a healthcare card. Then a secondary ID could include a Medicare card, council rate notice or utilities bill issued in the past 3 months, or an ATO or other government agency notice issued in the past year, or an electoral roll details which have been checked against aec.gov.au. For an individual under the age of 18, a letter from a school principal issued in the past 3 months that details the individual's name, their residential address, and when they attended the school. Or a student card, if available, is also considered to be a secondary ID. So the evidence that we need to validate a representative of an individual client, you could use as official or legal documents such as an enduring power of attorney or a letter of authority. And then to verify a parental or guardianship relationship for a representative, you can cite a birth certificate, an adoption paper, court order, letter of authority, or a signed doctor's letter with an explanation of circumstances. So let's now move on to discuss the minimum POI requirements for a non-individual client. So for a non-individual client who has an individual representative, you would need to verify the individual representative's full name and either their residential address or their date of birth, and a non-individual's client's full name and either its ABN, ACN, or any other details that will help you reasonably assess, using your professional judgment, the legitimacy of the non-individual's client identity and the authority of the individual's representative to engage you on behalf of the non-individual client. Now let's look at what evidence you should cite to validate a non-individual's client identity. So the documents there could be a current asset company extract, identifying the individual representative as a public officer, a trust deed, or a partnership agreement could be used. Again, using your professional judgment and expertise to verify that the individual is authorised to represent the client. Either original documents or certified copies of the original documents can be used for ID purposes. So when you are citing these documents, you really need to make sure that the photo in the ID matches or appears to match the details and appearance of the client and other representatives. So for example, looking at age, gender. Also check to make sure the name, address and date of birth all match the information provided by the client or their representative. So we also know that it's not always possible to cite IDs in person and often will need to rely on electronic communication. And there are various ways you can safely and securely obtain IDs electronically. So some ways you can do this is to organise or obtain IDs electronically from your clients, and including use of secure websites, secure online mailboxes, or secure messaging. We strongly recommend not to use email for communicating sensitive information such as IDs of clients, except where you use an encrypted or password protected attachment to send or receive personal information. And we recommend extreme caution when communicating via email, as it's not a secure form of transmission, and we definitely are seeing the risk of emails being intercepted by third parties during transmission. So please be aware of that. We recommend you obtain professional advice from an ICT security provider as to what controls are appropriate for your business. If you engage with clients remotely and use a webcam or video conferencing to cite documents, make sure to record a note of the POI checks done, and I will discuss record keeping requirements a little bit later. But in circumstances where you engage with a client online and without a visual medium, you should refer to the ATO's requirements for verifying their identity. So what should we do for well-established clients? So let's look at those. So we understand that you would have clients that you have provided services for year on year and have a well-established relationship with them. For these clients, while it might not be practical or even necessary to conduct POI checks, we do recommend that you first assess the need to conduct a check on them. And you could do this as part of the annual accounts or tax return process, or when you're doing the next BAS. So to make this assessment, you can consider factors such as the extent of your relationship and the familiarity with the client, the nature of your client or the representative's requests, whether they're requesting a change of contact details or bank account information, or requesting an amendment to a tax return or statements resulting in higher refunds. Any change in your client's circumstances, if you see any discrepancies in relation to the client's identities or other affairs, and any change in the relationship between the client and their representative. So in a previous webinar, we've talked about financial abuse and a lot of those sorts of things, and coercion. So that would be some of the reasons that, you might want to, be checking a few of these things as well. and ensuring that you are actually getting instructions from the person who you believe it is. These factors can also guide you in determining how often you should undertake POI checks for existing clients. So if following that assessment, you decide that a POI check is not necessary for an existing client or the representative, you must keep a record of the factors that you considered to make that decision. So maybe in your file notes, you write down something to the effect that, you didn't do a POI check because you didn't deem it necessary, but just as long as you're, writing and taking notes of that. And as always, tax practitioners are expected to rely on their own professional knowledge and expertise in making these assessments, so your professional judgment. So what happens when we identify discrepancies? So when undertaking those POI checks, if you identify discrepancies with the information provided or claimed by the clients or their representatives, you should ask additional questions. Ask for additional documentation or evidence, or see if you can independently verify some of the information provided. If you are still unable to verify or are not satisfied with the information provided to ensure the identity is correct, you should decline the engagement. You should also consider notifying us, the ATO, ASIC, or any other relevant authorities. So what sort of records should you keep as evidence to show that you've undertaken POI checks? We do not require or even recommend that you keep copies or originals of any identification documents of your clients or their representatives. This is consistent with the Office of the Australian Information Commissioner's guidance, particularly in relation to Australian Privacy Principle 11, which is security of personal information. In fact, we strongly discourage this practice because we recognise these documents may be at risk of being stolen through cyber attacks or even physical break-ins at your business premises. However, we do require you to maintain a record such as a checklist for POI checks done, and you should note information such as the date and time the POI checks were done, the type of identification documents cited, so whether they were primary or secondary, and whether they were original or certified copies, how the documents were cited, either in person or electronically, and who performed the checks and their position within your practice. The record must also include confirmation that the identification documents were clear and legible and identified the client and their representative if applicable. There were no apparent reasons to question the identification documents provided. Again, if you decide not to undertake POI for a well-established client or representative, you must record your reasons. It is important you record these details as soon as POI checks are also undertaken, and you must keep these records for at least 5 years after the engagement with your client and your representative ceases. So let's, before we finish up with some questions, let's look at a quick example of record keeping and how a subsequent review of income tax return creates new record keeping requirements. So Carla is a registered tax agent who provides tax agent services through her company Helpful Tax Proprietary Limited, or Helpful Tax. Carla, on behalf of the company, prepared and lodged Dean's income tax return 4 years ago and kept relevant records of these services in accordance with the requirements of Section 30, the determination. Recently, the ATO undertook a review of Dean's income tax return completed 4 years ago, and Dean engaged as a Helpful Tax to represent him in the ATO review. Carla, on behalf of Helpful Tax, represents Dean in the ATO review, which is ultimately finalised 12 months later. So while the 5-year record-keeping period has now expired for the initial tax agent service provided to Dean in lodging his income tax return, the company has provided new tax agent services to Dean in representing him in that ATO review. As such, the company takes steps to ensure that it keeps records that correctly record the tax agent services provided to Dean in connection with the ATO review for 5 years from the date the services are completed, which was when the ATO communicated that the review had been finalised. So given their relevance to the ATO review, these records include documentation relating to the income tax return that was completed 4 years ago. Helpful Tax has complied with its obligations under Section 30 of the determination. So there's a lot of information in there, everyone. There's a lot of detail. So Trevor, over to you now for some questions.
Thank you, Amanda. Thanks for the presentation. Now, we've got a whole load of questions come in. Now, don't forget, if we don't get to your question, we do answer all questions after the webinar, and you'll be able to find them on our webinar resource hub. Let's go through some of them. This one came in from somebody called Andrew. How long will my application for approval to use the services or employ a disqualified entity take?
Yes, typically the TPB will decide an application for approval within 60 days of receiving the application, or within that longer period, as I explained, if it's agreed on between TPB and the registered tax practitioner.
Okay, and here's another one. This one's somebody called Jenny. Are there penalties for failing to comply with the DE requirements?
Yes. So if you are, thanks, Jenny. If you are a registered tax practitioner and you do not comply with the disqualified entities requirements, you may be in breach of the code, we may impose sanctions for that breach. If you are a disqualified entity and you do not notify the tax practitioner who employs you or uses your services that you are disqualified, you may be liable for civil penalties. And you need to refer to the civil penalties provisions, which I spoke about, the number of units that could potentially be enforced. Great.
Thanks, Amanda. So we've got a couple of about POI ones, so let's pick on those ones. Here's someone called Derek. Do I need to verify the identity of long-standing clients who I've known for many years? I've seen this question come up quite a bit, I know, when we've done webinars on POI. So yeah, you've got a long-standing client. Yeah. I know you touched on it in the slide.
Yeah. So for long-standing or well-established clients, we understand that it might not always be practical, or you might not want to, to do those checks, and it might not be necessary. However, in those cases where you deem it that it's not necessary, you've known the client for a long, long time, their circumstances haven't changed, we do ask so that you do, still exercise professional judgment, because things can change. And if you do assess that it's not appropriate, that point that you do make notation of why you did not make that POI. So make a record of the reason that you didn't do it at that point in time, and make sure it's done at that point. So perhaps when, as I said, when you're engaging or they're engaging you for additional advice, or maybe at the as you're doing annual accounts, tax returns, or the next BAS and things like that. And you may actually have that as a process. That might be something that you do as either as a one-on-one basis, or otherwise you may choose at a certain time. Let's re-look at all of these things for our whole practice, as safeguarding your whole practice, that we're going to do this in line with the March BAS, or in line, and maybe have that as an additional thing on your checklist, and then you've got that as a practice-wide practice-wide process, basically.
So it's quite an interesting thing, isn't it? So do you think it's a framing question? Because I can see with an established client, it could be quite awkward, couldn't it? So it's more, as you say, how you frame it. Thing that,
and you may just want to, say you've had that, and just double check, and maybe, at the time, you may not have actually, done a POI at the beginning, and you just feel like you just would like that on your records. So the other thing there is, if an individual representative has engaged you on behalf of a well-established client, we require you to cite evidence demonstrating that authority of the representative to engage you on behalf of that client before you provide tax or BAS agent services. So that could be you have a long-standing client, but then now have got a representative to actually engage with you, and you would need to make sure that you do have that authority on the system.
Okay. The next question from someone called Frank. And again, this is a thing I've seen come up, been asked a couple of times. How do we verify the identity of an overseas individual client or their representative?
Yeah. So, yeah, with that one, you can use primary photographic ID documents such as a driver's licence or a permit from Australia or overseas, including a digital driver's licence, an Australian passport, foreign passport issued by a foreign government or the United Nations, or international travel documents issued by a foreign government or the United Nations. So if you are engaging with the individual client or the representative remotely, such as through the use of, video conferencing, you should also consider the guidance on remote verification processes, which is inside our practice note.
Sure. Okay. Yeah, and that's right. The practice note will be available on our website. So let's just go to another one. So. Yeah, so do we only have to, so if we're looking at POI, do we only need to cite things, or do we have to keep a copy?
No, you do need to keep a copy of, we don't want you to keep copies of the actual documents. We just need you to, write down and notate, what they were. I've got just a clarification. Let me just double check the exact thing for everyone. But it's basically what you've cited, whether it's a primary or a secondary, whether you cited it in person or online, the date and the time, and also, this is from memory, and also the person and the position of that person in your firm. So just a notation of that. So, a checklist, just have a checklist that you have that, you're not taking down document numbers or anything like that. We don't want anyone to keep document numbers. We don't need to keep photocopies. But if you have a sheet with all that, with all the things that we have on our website that I talked about in that slide, and then just tick those things off, and it's all standardised, and then you file that. So nothing, if someone got that piece of paper, they could not have anything that they would be able to use to, from Amanda Gascoigne, that they could go and use.
So there's no privacy concerns, no. Yeah.
No privacy. So if you have that as an internal document and someone stole that client's file, or they cyber hacked and looked at that, it's not going to allow them to go and set up an account in the name of Amanda Gascoigne, a false account, or do anything there. It's all it is saying that we've cited it and what we've cited. So it's, it's protecting, as I talked about, protecting your practice and protecting the client's identity. So, yeah. So think about that when you've got that piece of paper, that it's actually covering yourself, that you've done the identity check, but no one else could actually go and use that to do anything. Criminal activity.
So again, you touched on this in the presentation itself. So it's really one of record keeping, isn't it? And maintaining
it's really a record keeping. Yeah, and just making sure that you know who you're working, who's engaging you, who's instructing you, and you've got all that, as I said, to cover yourself and the client.
Okay. And then I've just, again, this one's from Duncan. I think it's question number 12. How do you know if someone's disqualified? Is there a listing?
How do we know if someone's disqualified? So you'll be able to check that on the TPB search functionality, and it will say whether they are actually disqualified.
Okay.
Yes.
Let's find another one.
Yeah.
I thought it was useful that you touched on I didn't know whether you wanted to go back over the anti-money and counter-terrorism financing. Yeah, money laundering.
Yes. Yeah, so the anti-money laundering. So as I said, we had a really great presentation yesterday. The TPB had from Austrac, and I guess that only came out last week. But I would definitely, if you haven't seen that, have a look at the accounting program starter kit. It's been very well designed, and the proof of identity information in there. It's slightly different to what we have currently. my thoughts are that if you're actually providing one of those designated accounting services and you're doing the proof of identity and following the AUSTRAC proof of identity process, you will definitely be meeting the TPB. But as I said, we're going to look at the guidelines, because if there's a possibility that they can be one and the same, that could be something that just makes it easier for agents. So they're not thinking, oh, do I have to do this for AML CTF? Do I have to do this for TPB? So we'll be looking at that in the coming coming weeks and months and issuing guidance on that. But yeah, have a look at the AUSTRAC website. Really encourage everyone to look at that, get a bit of ahead of the game before the changes come in, the tranche 2 changes come in for the accounting industry on 1 July 2026.
Yeah, great. And I just, I can see Isabel's answered that in the questions, but also she's given a web link, which I won't, well, I can read that. It's austrac.gov.au /
Just go to austrac.gov.au. I just Googled it. Just if you just type in AUSTRAC accounting program starter kit, or just austrac.gov.au reforms, you'll be able to see it. So it's under accountants guidance, and they have done an excellent job and co-designing a lot of that with professional bodies. TPB made a submission as well, so it's they've done a lot of work with our industry, which is great.
That's terrific. We also issue a hyperlink document as well, so it'll be on there. So yeah, it's austrac.gov.au / AMLCTF reform. So so as I say, if you haven't got a chance to write that down, then it'll be on the link to this webinar.
Yeah. Robert's got it. I'll just have a quick look at some of these questions. Robert has, could you prepare a template we could use with necessary spaces? Robert, was that referring to the proof of identity? If Robert could confirm that. Maybe that's what it was for. What if the ID has expired? Yeah, Wolfgang, I would, if ID has expired, that would definitely be something that I would be looking at,
I think that's very true. Yeah, that'd be strange.
Yes, if the ID has expired, that's great. So I would definitely be doing that POI again for that. There's lots of questions. So do we know if BAS agents will fall under this new money laundering legislation? I think you just have to look to see what is it if a BAS agent is providing one of those, what are the services? You may, I would still definitely look at it. And then they have a tool that you can actually go and answer the questions, and it will actually give you an indication on whether you are going to be considered to be providing one of the high risk services. So I would encourage all BAS and tax agents to go and do that. The interactive tool, and double check that. So yeah.
I think that's quite an interesting question. I'm not sure you can see in the folder questions from presenters. Jesus asked a question about, why not prohibit the use of disqualified people without exception?
Why not to prohibit? Yeah.
Yeah.
That's a good question. So, it might be that, some of those things are personal bankruptcy. So it could be something that the person hasn't done any, or it might be, personal situations where they may still, be operating with integrity. They just can't operate their own practice. And one of the things is, we need to look at whether someone can continue their livelihood. And in those situations, under correct circumstances, under TPB approval, and under that correct supervision, etc., and depending on what role they're doing, all of that, there is an opportunity for those people to still be able to work, earn a living, and actually, contribute to the accounting profession still. So there's a lot of reasons why someone could be, convicted of some of those offences and that, and some of those are able to then be able to work in a practice with adequate supervision, etc. So I think
so
that's
it's really
probably
it's something about relevance, isn't it?
It's relevant, and I think that's we've all heard of different situations where people have, have got into a situation where they still need to work, and if they are able to meet the requirements, that we can actually give permission for that. So I think it's a really interesting topic, because when we were putting the slides together, I think it's probably an area where there'd be a lot of practices that don't actually know, that or haven't actually come into contact with the disqualifying entity. But, practices may actually get an unsolicited, when I was in practice, I had someone come in and drop their resume into me. And I think, okay, maybe I didn't have a job, a position at the time, but in that particular case, I did actually employ that person. So that is quite normal that someone may just go and drop a resume off. Now, we do have to make sure that that person isn't a disqualified entity, because in the past we've just thought, well, someone has just, turned up on our doorsteps. But we do have to make sure that those checks are in place, because there may be that person has just left employment for normal reasons. Maybe they have actually, they are actually a disqualified entity. Sometimes they may not actually disclose that, which is why that process needs to be done no matter what. Yeah, so I think it's a really, I think a lot of agents may not actually have, this may not have even been on their radar when they got that resume in and think, okay, I need some support. This just seems to have come at such an opportune time, and just go through their normal, recruitment process, and have a look at suitability, qualifications. Quite often the things that I went through would not be that normal process. So we really need everyone to be mindful, of when they're employing or engaging someone to do that. Does that make sense? I hope that's give it a bit of context.
I think so. Yeah, I think that's right. Can you? Sorry, if you can help me out. Just maybe we've got time for one more quick question. Let's see.
And if there are other questions that we haven't been able to answer, as Trevor said, we'll come back with that, with some additional things. So it's lovely that we've got lots of questions, and it was really text-heavy content. But if we've got some other questions, or if there isn't anything that we explained, please let us know. Good. There's a question there, 65, from Vito. Should practitioners be aware of how AI can modify a person's identity? That actually is a really good one as well. And, in the past, we may have just accepted every, documents that are provided to us face value. So with AI and with the ability to doctor, documents, one thing for me would be just to make sure that we're using that professional judgment as well. Maybe it's not just accepting things on face value, but making some further inquiry. So in the past, where we've had a birth certificate or we've had something, we may have just accepted it, but maybe we have to, think about, and I think one thing I would say here that, I talked about it right at the very beginning, the majority of agents are doing the right thing. And, some of these issues that we're seeing play out, never been, accustomed to them, wouldn't even think that some of these things would happen. And, it could be that, it could be a naivety thing, but I think we now need to actually be really on our guard and looking at things and questioning it. So that's also even for POI. That's even when clients give us information, that I think sometimes we have to make additional inquiries that perhaps we wouldn't have 10 years ago.
Just simply because the AI world we live in. Yeah.
I think that's a really great question. That, my advice to practitioners would be to be extra vigilant, to to not take things necessarily at face value and do that extra. If you've got I think one of the things that I talked about was verifying, you know, another area. So you might verify something else. And that might not be that it's part of a checklist, but it's, you know, if you're sitting with something and you're not quite sure, or something just looks a little bit odd,
professional judgment.
I would go with intuition and use that professional judgment. It's not going to hurt. So that is a really good question. And, you know, that's some of the things that, you know, I think ATO, TPB and the professional bodies and everyone will be looking at, like, what are the emerging risks? What are some of the emerging things that we have to perhaps change our processes? It's a really new world that we're living in. And, you know, a lot of this stuff, as I said, you know, the remote work, the ability, you know, all of that is so great, but it does actually come with risks, and that is going to change what a practice looks like in the future and what some of our things need to happen. Yeah.
Fabulous. Well, thank you, Amanda. I've been very grateful to have your knowledge and wisdom. I can just see that the clock's moved to an hour, so let me just wrap up really quickly. If you'd like more information and to keep up to date, obviously our website's always there 24 hours a day, tpb.gov.au. You can follow us on LinkedIn and Facebook. Don't forget, we've also got a newsletter that goes out. Got a huge number of subscribers for that, TPB News, and you can subscribe to that at our website as well. Also, check out our YouTube channel where we post new videos. This will ultimately be posted on there as well, and we've got a comprehensive list of all the webinars. And you can also claim CPE for watching the videos on YouTube. Thank you ever so much, Amanda. It's been great to hear your insights. And also to Kristen, Isabel and David, who have been on the chat, answering and assisting you with your questions. Thanks to everyone in the audience for sending through those questions. As Amanda said, we've had an awful lot of questions today. If you're interested in attending more webinars, don't forget that we've got our second webinar of the day this afternoon at 2 o'clock, Navigating TPB Compliance, What's Coming in 2026. So if you haven't already registered, you can do that. And then if you can just click on to the very final slide, I'll just be launching an exit survey when the webinar ends, and we'd appreciate if you can take the time to complete the exit survey. It only takes a moment, and your feedback helps us improve our webinars and lets us know of any topics that you might be interested in, and we can obviously look at those in the future. Our survey will open in the browser once you leave the webinar. Once again, thank you ever so much for joining us, and we hope you enjoy the rest of your day. Thank you.
Thank you. Thanks, Trevor. Thanks, everyone.